All right. Hey guys, how's it going? It's me. It's 10 o'clock p.m. on February 21st. And just a quick, maybe not super quick, but relatively brief um, stream here. I wanted to talk about a question that I got asked from an agent uh, about an hour ago. And the question is there not some type of board within the MLS that hears these cases and rules? Um, so I wanted to talk about the front end leading up to what caused this question to be asked, and then the back end, which will be to actually answer this question itself. So, for the front end, what happened was, and then the reason half the reason I wanted to talk about this is the front end, and that is that it is very important to remember that if you have a contingency on the sale of a home, so let's say you're representing a buyer, and the buyer needs to sell their home before they can qualify for the loan to buy their next home. And so you're writing an offer for the buyer to buy their next home, and the question comes up from the client, hey, do I really have to disclose that my offer is contingent upon the sale of my home? Because I know that will make my offer weaker. So can I not, is it okay for us to not make the offer contingent upon the sale of my home, knowing that we still have the protection of the financing contingency, right? Because if my home doesn't sell, then my lender is not going to give me my loan, and therefore can't I just use the financing contingency to protect me? And if so, then maybe I don't need to disclose that my offer is contingent upon the sale of my home, and therefore we can submit a stronger offer. And the answer to that question is no. No, you can't. I suppose you could. A client could do that. And I suppose if nobody opposed what the client was trying to do, that it might work. But if challenged, if you had a client that wanted to do that, they wanted to write an offer contingency free, even knowing that they had to sell their home before they could buy, and they wrote a clean offer without a contingency, their home didn't sell, and now you're trying to terminate pursuant to the financing contingency. If the other party challenged, you're going to lose. And the reason you're going to lose is that it's weird. We all think that when we think of adverse material facts, we think of things that are of or having to do with the home's condition. The home had a water intrusion and there's mold. Oh, that's an adverse material fact. I have to disclose that. But the reality of adverse material facts is much larger than that. You have all kinds of things. So, without getting into too many examples, I'll cut straight to the main example here, which is the buyer's need to sell their home before they can qualify for their loan to purchase is considered to be an adverse material fact, and buyers have an obligation to disclose those to sellers. It's something that's not often talked about. It's kind of weird when you talk about it, because we all talk about it the other way. It's all about the condition of the home, but it's not limited to that. Buyers have an obligation to disclose adverse material facts to sellers. So another instance would be like we lost our job, and now it looks like we're not going to be able to qualify for our loan, but we want to hide that from the seller because we're going to try and find some other way. You can't do that. When something bad happens that's going to prevent a transaction from closing, there's an obligation to disclose those types of things. So In this particular instance, the Atova agent was working with a seller client, so our listing, and an agent wrote an offer contingency free on one of our listings. And then half a day later, came back to us and said, after we got into contract and we took this brand new listing and put it pending in the MLS, they come back half a day later and say, oh, well, we couldn't get out of our lease, and so we need to terminate. Well, the offer was clean. There was no contingency written into the contract. This agreement's contingent upon the buyer's ability to terminate their existing lease on whatever property at no cost to the buyer. There was no contingency in there. There was no mention of this lease at all. And now the agent, the buyer's agent, is attempting to tell us and tell our client that they're not going to post the earnest money, and we're not entitled to the earnest money because they're terminating pursuant to the financing contingency. And it does not work that way. You can't write a contingency-free offer and then come back later and say, oh, we couldn't get out of our lease, so we're leveraging the financing contingency to terminate. It does not work that way. If you're writing an offer that's contingent upon a buyer's ability to sell their home prior to buying their next home, or a buyer's ability to get out of their lease before buying their next home, or anything that is outside of the ordinary process, there's an obligation to disclose those things. And if you don't disclose those things, that is arguably a violation of Idaho real estate law and is a problem, right? And at the very least, it's acting in bad faith. It doesn't follow the terms of the purchase agreement, and in my opinion, as a designated broker, my opinion is that in this circumstance, the buyer needs to post the earnest money as they contractually agreed to in the RE21, and then that earnest money should be forfeit to our seller client because the buyer breached. There was no provision in the agreement to terminate pursuant to the financing or to if they couldn't get out of their lease. And that's the reason they've told us that's the reason they backed out. So they backed out for a reason that wasn't a contingency of the contract, and their bad faith use of the financing contingency to attempt to do so after the fact is ridiculous. So that's our position, and we've made our position clear. The other agent and the buyer is simply saying, nope, here's our letter from our lender saying we couldn't qualify. Thank you very much. Have a nice day. So we're currently at a bit of an impasse, and that takes us to the back end. So the Atova agent is asking me, hey, can't we take this to the board or something? How do we make sure that our client gets taken care of? And so I was drafting an email response to the Atova agent, and I figured that I would do this stream to kind of talk through it at the same time. So first thing here is money issue between clients, or we should probably better say this is money issues between consumers. When there's a money issue between a consumer, a buyer and a seller, they're both going after the earnest money or some other fight between consumers, that's going to be a matter for attorneys and the courts. So when it's a money or a contractual issue that buyers and sellers are fighting over, the appropriate party to deal with that is attorneys and the courts. When there's a money issue between agents, so commission, procuring cause, those types of issues, those matters are dealt with the local realtor association. So in this case, it would be BRR and so the Boise Regional Realtors and the Ada County Association of Realtors and the Idaho Association of Realtors. So the association would handle those matters. If an agent commits an illegal action, if an agent does something illegal, then that matter is the responsibility of the Idaho Real Estate Commission. And then lastly, if an agent does something that's unethical, that's something that is handled by, again, the Realtor Association. So, recapping here, money issues between consumers, attorneys in the courts, money issues between agents, the Realtor Association, illegal actions by an agent, the Idaho Real Estate Commission, and unethical actions by an agent, again, is the Realtor Association. So when the agent asks, is there not some type of board within the MLS that can hear these cases and rules, what they're really, so the answer to that question is, this is a battle for earnest money. The seller is saying, hey, I'm entitled to that earnest money. The buyer is saying, no, I'm out of here pursuant to the financing contingency. That's a matter for attorneys and the courts. So what we're doing right now with the client is telling the client is, the buyer is effectively stonewalling us, saying, nope, not going to post the earnest money, and we're free and clear because here's our lender from our letter from our lender saying we can't qualify. So the next step and the way that we're going back to the client right now is to ask them, hey, we can escalate. We can tell this buyer that either they post the $2,000 earnest money and release it to us, in which case we'll call it even, or if they don't agree to do that, our client is going to hire an attorney, and the attorney is going to be going after your buyer for a lot more than the earnest money. They'll be going after the buyer for actual damages, plus attorney fees and filing fees and court costs. And so, we're no longer talking about $1,000 earnest money. Now we're talking about, these things add up quick. We could be talking about $5,000, $10,000, $15,000 by the time that we're done. So either post the earnest money, refund to the seller, or our seller is going to hire an attorney, and this is going to get a whole lot worse really quick. And then after we send that type of email, the next stage of escalation after that is a letter from an attorney saying, post the $2,000 plus give me a check for $300 for writing this letter, or we're taking you to court. And it's just escalation, escalation, escalation. So in this instance, the agent is wrong in their interpretation that their buyer client is entitled to withdraw, given that they've produced this lender letter. The agent is wrong about that, but that's not an illegal action. So we could report this agent to the Idaho Real Estate Commission and tell them, hey, this is the situation, and this is what the agent is saying. And the Real Estate Commission would be happy to re-educate that agent, but they're not going to take any action, I don't think, against the agent. They're just going to call the guy up and say, hey, look, in this type of situation, you can't leverage the financing contingency. You have to disclose this from the beginning. So we could report him to the Idaho Real Estate Commission, and the Idaho Real Estate Commission would educate the agent. At least that's what I expect would happen. I don't speak for the Idaho Real Estate Commission, and I can't say for sure what they would say, but that's what I would expect that they would probably do. And I don't think the agent's done anything unethical. I think they misunderstand how it works, but I don't think there's anything unethical there. So I don't think there's anything here. There's no money between agents in dispute. So the two courses of action that we have at this juncture would be to leverage the threat of escalation, which of course we can do only at our client's direction. And then the other thing we could do is help that other agent learn and be a better agent by having the Real Estate Commission explain to them because they're not taking our word for it. So that's that. I know that's a little bit kind of all over the place, but I wanted to cover a lot of ground and just kind of talk through some things. The main thing to remember here, though, is these escalation paths. If you ever find yourself in a dispute with another agent and you need to bring these types of escalation threats. I hate that word, but if you need to tell another agent that, hey, we've got to do this right, because if you don't, we might find ourselves needing to talk to an attorney, or we might find ourselves talking to the real estate commission. So it'll be helpful for you guys if you're ever in those conversations where you need to threaten escalation. It will carry a lot more weight if you are sharing an escalation path that is actually commensurate with the issue at hand. Hello, puppy. I think my daughter just got home. And she's saying, "Hi, Abby." Yeah, so it just makes sense to know what you're talking about, right? So if you're in an argument or a dispute with another agent, and you know that what they're doing is illegal, then you could say, "Hey, look, I think what you're talking about here is not legal, and if you go down that path, you could find yourself in front of the real estate commission. You don't want that." But if they're doing something illegal, and then you say you could find yourself in front of the realtor association, it's a mismatch, right? So I think knowing the different entities that handle the different types of issues is important for you guys to know, and hence this stream. And then the last piece of recap is, remember that when you're writing an offer and it is contingent upon the sale of a home, or it is contingent upon getting out of the lease, or it is contingent on this job coming through, you have an obligation as an agent, as a licensee. You have an obligation to disclose those things, and if you're going to later leverage one of those things to terminate, it better be established as a contingency of the agreement. Because if you're going to try and do this bad faith end run, leverage the financing contingency to do that, you're going to find yourself on the losing end of an argument. So anyway, that's it for now. Hope that you guys found that helpful, informative, and somewhat interesting. And until next time, have a great night. Thanks. Bye-bye.